The waterfall had been there long before the roads, long before the expensive houses, and long before anyone had ever thought of creating a homeowners association. Nestled deep in a narrow valley surrounded by pine-covered hills, the falls poured over a rocky ledge into a crystal-clear basin before winding downstream through private land. For generations, locals had known about it. Hikers occasionally visited it. Photographers came during autumn when the leaves turned bright shades of orange and gold. Families stopped by during summer weekends. But despite its growing popularity, the waterfall remained largely untouched. Most people assumed it belonged to the state. Others assumed it was public land. Very few knew the complicated reality. The waterfall itself sat on land owned by a family trust that had existed for decades. The surrounding acreage had once been part of a large ranch before being divided over the years. The trust maintained ownership of the waterfall property and the stream corridor surrounding it. I happened to be the current trustee. My grandfather had purchased the property in the 1960s when the land had little value beyond timber and grazing rights. He had always viewed the waterfall as something special. He never fenced it off. He never charged visitors. He simply asked people to respect the area. For decades, that informal arrangement worked perfectly. Then the developers arrived. Everything changed within a few years. The hills overlooking the valley became prime real estate. Luxury homes appeared one after another. The area was marketed as a secluded mountain community for wealthy retirees and remote professionals. Soon, hundreds of homes occupied land that had once been open forest. With the homes came a homeowners association. At first, the HOA seemed harmless. They handled landscaping for common areas, maintained entrance signs, organized neighborhood events, the usual things. I paid little attention. My property wasn't part of the subdivision. The trust land existed independently. Legally, the HOA had no authority over anything I owned. For several years, there were no issues. Then social media discovered the waterfall. Drone footage began appearing online. Travel influencers posted videos. Outdoor bloggers listed it among hidden destinations worth visiting. Weekend traffic increased dramatically. The narrow county road leading toward the valley became congested. Visitors parked wherever they could. Some parked responsibly. Others did not. The neighborhood residents became increasingly frustrated. Complaints began appearing on local community forums. Residents blamed tourists. Tourists blamed residents. Everyone blamed someone else. Still, none of that involved me directly. Until one Saturday morning. I was walking one of the trails near the stream when I noticed something unusual. A large wooden structure had appeared near the entrance road. At first glance, it looked like a welcome sign. As I approached, I realized it was much more than that. The sign carried the HOA's logo. Beneath it sat a small booth. Several orange traffic cones narrowed the roadway. A banner stretched across the entrance. Visitor access permit required. Below that was another message. Waterfall access. $20 per person. I stopped and stared. The booth had not been there the previous weekend. Someone had clearly invested significant money constructing it. Several tourists stood nearby, while volunteers collected cash. People received colored wristbands after paying. Others were being directed toward parking areas inside the subdivision. For a moment, I wondered whether I was misunderstanding something. Then I noticed a map. The map displayed my waterfall. The map displayed my property. The map displayed hiking routes crossing trust land. The HOA was charging admission to my waterfall on land they didn't own. I walked closer. The volunteers looked busy. Families handed over money. Visitors accepted brochures. The entire operation appeared organized, professional, intentional. Most importantly, profitable. I spent the next hour quietly observing. Vehicle after vehicle arrived. The money collected quickly accumulated. The line rarely disappeared. By lunchtime, it was obvious that hundreds of dollars were changing hands every hour. The HOA had essentially created a private tourist attraction overnight, without permission, without consultation, without legal authority. I left before anyone recognized me. Instead of confronting anyone immediately, I wanted information. Experience had taught me something important. People making bad decisions often reveal more when they believe nobody is watching. Over the following week, I investigated. The deeper I looked, the worse things became. The HOA board had discussed the waterfall for months. Meeting minutes revealed growing frustration about visitor traffic. Residents complained about noise, parking, litter, trespassing. Rather than working with county officials or property owners, the board developed a different plan. They would monetize the problem. According to internal documents, they described the waterfall as a community asset. The phrase appeared repeatedly, community asset. The problem was obvious. The waterfall wasn't their asset. Never had been. Yet somehow they convinced themselves otherwise. The HOA established parking fees, visitor permits, special access passes. They even began advertising online. The brochures claimed proceeds would support trail maintenance and environmental protection. That sounded responsible, until one looked closer. The HOA didn't own the trails. The HOA didn't maintain the waterfall. The HOA had no environmental authority. They were simply collecting money, lots of it. A financial report eventually found its way to me through a concerned resident. The numbers were shocking. In only 3 weekends, the operation generated thousands of dollars. The board celebrated the revenue. Residents praised the initiative. Nobody appeared concerned about whether it was legal. That changed when I sent a formal letter. The letter was simple. The trust owned the waterfall property. The trust owned the access corridor. The trust had never authorized admission fees. The trust demanded immediate cessation of all commercial activities involving the property. I expected resistance. I did not expect arrogance. The HOA responded through their attorney. Their position was astonishing. They claimed visitors primarily accessed the waterfall through roads maintained by the HOA. Therefore, they argued, they possessed authority to regulate access. The argument ignored one major detail. Regulating access was not the same thing as selling access. A parking fee might have been debatable. Charging admission to someone else's property was not. Still, they refused to stop. In fact, they expanded operations. The next weekend featured additional signs, additional volunteers, additional promotional materials. It was as if my letter had encouraged them. The board apparently believed I would eventually back down. They had money, lawyers, influence. Many residents shared that confidence. After all, they were a large organization. I was one trustee managing family property. The power imbalance appeared obvious. Unfortunately for them, appearances can be misleading. The waterfall property came with a complicated legal history. Decades earlier, portions of the stream corridor had been placed under conservation agreements involving state agencies. Certain environmental protections existed. Certain access rights existed. Most importantly, certain commercial restrictions existed. Those restrictions were not widely known. Even I had forgotten some details until reviewing old records. One document immediately caught my attention, a decades-old memorandum referencing state oversight concerning recreational activities along protected waterways. Another referenced ranger jurisdiction. A third discussed penalties for unauthorized commercial exploitation of protected natural resources. The more I read, the more interested I became, because the HOA's actions suddenly looked far more serious than simple trespassing. They might have crossed into regulatory territory, the kind that attracts government attention. I gathered every document I could find: property surveys, conservation agreements, historic maps, easement records, environmental filings. Boxes of paperwork accumulated across my dining room table. For nearly 2 weeks I reviewed everything. Meanwhile, the HOA continued collecting money. Visitor numbers increased, revenue increased, their confidence increased. Then something happened that accelerated everything. A tourist posted a viral video. The video showed the entrance booth, the wristbands, the fee collection process, the promotional signs. Millions of people suddenly learned about the waterfall. But the comments section contained an unexpected question. Hundreds of viewers began asking the same thing. Who actually owns the waterfall? That question spread quickly. Local reporters noticed. County officials noticed. Residents began asking questions. The HOA board responded by doubling down. Public statements described the operation as beneficial, responsible, necessary. They portrayed themselves as protectors of the area. The narrative worked for a few days. Then one reporter contacted me directly. I provided copies of the property records. The resulting article created immediate controversy. For the first time, the public learned the waterfall belonged to neither the HOA nor the state. The public learned admission fees were being charged without owner permission. The public learned the situation might not be legal. Pressure began building. Residents demanded explanations. Visitors requested refunds. Local officials started making phone calls. And somewhere within the growing chaos, a state office received a complaint packet containing every document I had assembled. 3 days later, while checking trail conditions near the waterfall, I noticed a government vehicle parked beside the stream. The emblem on the door immediately caught my attention. A state ranger stepped out carrying a clipboard. The ranger spent nearly an hour examining signs, photographing structures, and reviewing maps. Then the ranger walked directly toward the HOA's admission booth. For the first time since this entire mess began, The volunteers behind the booth looked nervous, because unlike letters from property owners, requests from reporters, or complaints from tourists, a visit from a state ranger was something entirely different. And judging by the expression on the ranger's face, the HOA was about to discover exactly how different. The real confrontation was finally beginning. The moment the state ranger arrived at the entrance booth, the atmosphere around the waterfall changed. For weeks, the HOA had operated with complete confidence. They had ignored legal notices, dismissed property records, brushed aside criticism. They acted as if the situation was already settled, and that anyone questioning their authority simply didn't understand how much influence the association possessed. That confidence began evaporating the second a government vehicle appeared beside the stream. The ranger spent the remainder of that afternoon documenting everything. Photographs were taken from multiple angles, measurements were recorded, signs were examined, copies of brochures were collected. The fee schedules were photographed. Even the temporary structures built by the HOA received careful attention. Nothing appeared rushed. Nothing appeared emotional. The ranger simply gathered facts. That methodical approach made many residents uneasy. Government officials who arrive angry can sometimes be argued with. Government officials who quietly document everything are often far more dangerous. Word spread quickly through the neighborhood. By evening, social media groups dedicated to the subdivision were exploding with speculation. Residents who had enthusiastically supported the tourism program suddenly began asking questions. Others insisted the HOA had done nothing wrong. Several board members attempted to reassure everyone that the visit was merely routine. Unfortunately for them, reality soon became impossible to hide. 3 days later, official notices began arriving. The first notice went to the HOA management office. The second went to the board president. The third went to the association's attorney. The language inside those notices was remarkably direct. The state was initiating a formal review regarding unauthorized commercial activity connected to protected natural resources. Those words immediately changed the conversation. Unauthorized commercial activity. The phrase sounded much more serious than visitor management, much more serious than parking control, much more serious than community improvement projects. For the first time, residents began realizing the situation might extend far beyond an ordinary property dispute. Meanwhile, the ranger continued investigating. Over the next 2 weeks, multiple site visits occurred. Additional records were requested. Historic conservation documents were reviewed. County permits were examined. The state eventually contacted me directly. I provided every document I possessed: old surveys, historic deeds, environmental agreements, correspondence dating back decades. The deeper investigators looked, the more complicated the situation became. The waterfall itself wasn't merely a scenic attraction. The stream feeding it had been included in several conservation programs over the years. Special protections existed because of wildlife habitats downstream. Various agencies maintained overlapping responsibilities. Most people never noticed these details because they rarely affected daily life. The HOA apparently never noticed them at all. That oversight was becoming increasingly expensive. Several weeks into the investigation, another problem surfaced. A local journalist obtained internal HOA emails. The resulting article created a firestorm. The emails revealed discussions that looked terrible when viewed publicly. Board members repeatedly referred to visitors as revenue opportunities. Financial projections estimated future profits. Plans existed for expanded tourism programs. One email proposed premium access packages. Another suggested seasonal festivals. A third discussed increasing admission fees once public awareness grew. The article quickly spread across regional news outlets. Public opinion shifted dramatically. What had initially appeared to be a neighborhood attempting to manage tourist traffic now looked like an organization trying to monetize property it didn't own. The distinction mattered a lot. Residents became divided. Some defended the board, others demanded resignations. Emergency meetings were scheduled. Attendance reached record levels. Parking lots filled beyond capacity. Community forums turned hostile. Every new development generated additional controversy. The board's response only made matters worse. Instead of acknowledging mistakes, they continued insisting they possessed legitimate authority. Public statements emphasized their maintenance expenses. They highlighted road improvements. They discussed security concerns. They spoke at length about visitor impacts. Yet one question continued resurfacing. If they owned nothing connected to the waterfall itself, why were they charging admission? Nobody seemed capable of providing a convincing answer. The investigation accelerated shortly afterward. The ranger's office requested financial records. That request apparently caught the board by surprise. Suddenly, the issue wasn't simply whether fees had been collected. Now investigators wanted to know how much money had been collected and where that money had gone. The numbers proved astonishing. Over several months, the HOA had generated far more revenue than most people realized. Thousands became tens of thousands. Tens of thousands approached six figures. The popularity of the Waterfall had exceeded every projection. Week after week, tourists continued arriving. Week after week, admission fees accumulated. The operation had become extraordinarily profitable. That discovery attracted even more attention. County officials began asking questions. Environmental agencies became involved. State attorneys reviewed documents. What started as a simple complaint was evolving into something much larger. The HOA board appeared increasingly nervous. Board meetings became closed sessions. Legal expenses skyrocketed. Consultants were hired. Crisis management discussions emerged. Residents started receiving special assessments to cover mounting costs. That development triggered another wave of anger. Many homeowners had originally supported the tourism initiative because they believed it would generate revenue. Now they were being asked to pay for lawyers. The mood inside the subdivision shifted dramatically. Meanwhile, the ranger continued building the case. One detail proved especially significant. The HOA had installed directional signs not only on their own property, but also within areas covered by conservation agreements. Several markers had been placed near protected zones. Others appeared within regulated stream corridors. None of those installations had received authorization. Individually, the violations seemed minor. Collectively, they painted a troubling picture. Investigators began viewing the HOA less as a community organization, making an honest mistake, and more as an entity repeatedly ignoring boundaries, both legal and physical. The board's attorney attempted to push back. Lengthy letters challenged jurisdiction. Additional arguments questioned interpretation of regulations. Every response generated more paperwork, more reviews, more scrutiny. Months passed. Then came the meeting that changed everything. The state scheduled a formal administrative hearing. Representatives from multiple agencies attended. County officials attended. Environmental specialists attended. The ranger attended. The HOA attended. I attended as well. What unfolded surprised nearly everyone. For hours, evidence was presented. Maps covered entire walls. Historic records were displayed. Financial documents were reviewed. Photographs appeared on large screens. The presentation systematically dismantled nearly every argument the HOA had advanced. The property ownership issue alone proved devastating. The admission fee structure proved even worse, but the greatest damage came from the financial evidence. Investigators demonstrated that the HOA had knowingly collected money associated with access to land they neither owned nor controlled. The distinction was impossible to explain away. As the hearing progressed, the board members looked increasingly uncomfortable. Their earlier confidence was gone. In its place sat visible concern. The ranger's testimony proved particularly influential. Rather than focusing on personalities or motives, the ranger concentrated entirely on facts, documented observations, regulatory requirements, historic protections, recorded activities. The testimony was calm, detailed, and extraordinarily difficult to challenge. By the end of the hearing, the atmosphere had changed completely. Even observers with little legal knowledge could sense the direction things were heading. The HOA was losing. Badly. Yet the biggest surprise arrived several weeks later. A preliminary state determination was released. Most people expected warnings, perhaps modest fines, maybe a cease and desist order. Instead, the findings were far more severe. The state concluded there was substantial evidence supporting multiple violations. Commercial activity was immediately prohibited. All admission collection had to stop. Temporary structures required removal. Further penalties remained under review. The announcement hit the community like a thunderclap. News stations covered the story. Online commentators celebrated. Property rights groups shared articles nationwide. The Waterfall controversy transformed into regional news. Residents who had ignored the issue suddenly found reporters requesting interviews. The HOA board entered full crisis mode. Emergency meetings occurred almost daily. Several directors quietly resigned. Others attempted damage control. None of it worked. Every new headline worsened public perception. Then investigators uncovered something nobody expected. During review of financial records, questions emerged regarding how certain tourism revenues had been categorized. The issue wasn't necessarily criminal, at least not yet, but it raised enough concerns that additional agencies requested information. That development terrified the remaining board members. What had started as a dispute over a waterfall was now threatening the entire leadership structure of the association. For the first time, settlement discussions emerged. Representative approached me indirectly. They floated ideas, proposals, potential compromises. The offers arrived months too late. The situation had already moved beyond private negotiations. The state was involved. The Ranger's office was involved. Multiple investigations remained active. No individual property owner could simply make everything disappear. The machine had already begun moving, and government investigations rarely stop because someone suddenly regrets their decisions. As autumn approached, visitor traffic declined. The admission booth disappeared. The signs disappeared. The wristbands disappeared. The tourism operation that once generated enormous revenue vanished almost overnight. But the consequences remained. Lawsuits were beginning. Residents were demanding accountability. Former supporters were turning against board leadership, and investigators continued examining records. Then, just when many believed the worst was over, the Ranger's office released another notice. This one contained findings nobody had anticipated. The notice referenced potential restitution, potential recovery of improperly collected funds, and potential personal liability for individuals who authorized certain actions. The implications were explosive, because if those findings held, the HOA's problems were about to become much bigger than fines, much bigger than embarrassment, much bigger than a lost argument over a waterfall. And as winter approached, the people responsible for the scheme realized they might soon face consequences they had never imagined when they first decided to put a price tag on someone else's land. The final chapter of the story was only beginning. Winter arrived quietly in the valley. The crowds disappeared. The roads emptied. The waterfall continued flowing exactly as it always had, indifferent to the months of controversy that had consumed the community around it. Snow gathered along the cliffs. Ice formed near the edges of the basin. The forest settled into its seasonal silence. From a distance, it almost looked as though nothing had happened. But beneath that calm surface, the consequences of the HOA's decisions were still unfolding. In many ways, the real damage had only just begun. The State Ranger's latest findings sent shockwaves through the subdivision. For months, residents had hoped the situation would eventually fade away. Many believed the removal of the admission booth marked the end of the crisis. They assumed the state had made its point. They assumed the fines would be manageable. They assumed life would return to normal. Instead, investigators were now discussing restitution. That single word terrified everyone involved. Restitution meant more than punishment. It meant repayment. It meant calculating how much money had been collected and determining where that money should have gone. The process immediately created a new problem. The amount of money involved was far larger than most homeowners realized. As auditors reviewed financial records, they reconstructed the entire operation, weekend by weekend, month by month, fee by fee. Every wristband sold, every parking pass issued, every tourism package promoted. The final totals stunned the community. The HOA had generated extraordinary revenue through the Waterfall program. Far more than residents had been told, far more than many board members initially admitted. The figures became impossible to ignore. Local newspapers published detailed breakdowns. Television stations covered the story repeatedly. Online discussions exploded. The Waterfall controversy had transformed from a neighborhood dispute into a cautionary tale about power, greed, and accountability. Public opinion hardened quickly. Many residents who had once supported the board now felt betrayed. They had trusted leadership to act responsibly. Instead, they discovered major decisions had been made with minimal oversight. Financial risks had been ignored. Legal warnings had been dismissed. And now ordinary homeowners were being forced to deal with the consequences. Emergency community meetings became increasingly hostile. Attendance reached levels never seen before. Residents demanded explanations. Questions filled the room. Why had warnings been ignored? Why had legal advice apparently gone unheeded? Why had nobody verified ownership before collecting money? Why had the board continued after receiving formal objections? The questions piled up faster than answers. Every attempt to justify the program only seemed to create new problems. The situation worsened when additional documents became public. Through various records requests, reporters obtained communications showing that multiple individuals had expressed concerns early in the process. Those concerns had not been acted upon. In some cases, they appeared to have been dismissed entirely. That revelation destroyed whatever confidence remained. The controversy was no longer about a mistake. Many residents now viewed it as a deliberate decision to pursue profits, despite obvious warning signs. Trust evaporated. Board members began resigning, one after another. Some cited personal reasons, others referenced family obligations. A few simply disappeared from public meetings altogether. The resignations did little to calm tensions. If anything, they fueled additional suspicion. People wanted accountability. People wanted transparency. Most of all, people wanted someone to accept responsibility. The state investigation continued moving forward. Months of documentation had produced an enormous record. Property ownership records, financial statements, conservation agreements, photographs, permits, correspondence. The evidence painted a remarkably consistent picture. The HOA had repeatedly acted beyond its authority. The Ranger's office eventually finalized its recommendations. Those recommendations became the foundation for several subsequent actions. Commercial activities connected to the waterfall remained permanently prohibited without proper authorization. Various penalties were imposed. Corrective measures were ordered. Additional monitoring requirements were established. Yet perhaps the most significant development involved the money itself. A restitution framework was approved. The process was complicated. Thousands of visitors had passed through the area. Tracking every payment was nearly impossible. Still, investigators developed mechanisms for recovering and reallocating funds where appropriate. The financial burden proved substantial. The association suddenly faced obligations nobody had anticipated when the tourism project began. Legal costs continued climbing. Administrative expenses mounted. Insurance complications emerged. Special assessments increased. The community found itself paying for mistakes that never should have happened. Predictably, lawsuits followed. Some came from homeowners. Others came from outside parties. Different claims targeted different aspects of the controversy. The exact outcomes varied, but one thing became clear. The HOA's attempt to generate easy money had become extraordinarily expensive. Meanwhile, something unexpected happened. Public sympathy shifted toward the waterfall itself. Throughout the controversy, the natural landmark had become the center of countless arguments. Ownership disputes, revenue disputes, regulatory disputes. Yet many people began focusing on a different question. How could the area be protected moving forward? Conservation groups expressed interest. Outdoor organizations became involved. County officials discussed long-term preservation strategies. The conversation gradually evolved from profit to stewardship. That shift pleased me. The waterfall had never been about money. My grandfather understood that decades earlier. The land possessed value far beyond admission fees. People visited because the place felt special, peaceful, authentic. The HOA had viewed it as a business opportunity. That perspective ultimately caused their downfall. As spring approached, the valley slowly returned to life. Snow melted, streams swelled, wildflowers appeared, visitors began returning. But the experience looked very different than before. No admission booth greeted arrivals, no wristbands changed hands, no volunteers collected cash. The commercialization effort was gone. What remained was the waterfall itself, exactly as it had existed for generations. Several months later, the state ranger returned for a final inspection. The visit attracted little attention compared to earlier appearances. No television cameras waited nearby. No reporters followed. The drama had largely ended. Most people had moved on, but the significance of that final inspection was enormous. It marked the conclusion of a process that had lasted more than a year. The ranger walked the area carefully. Trails were examined. Former sign locations were reviewed. Stream corridors were inspected. The site met every requirement. The unauthorized structures were gone. The violations had been corrected. The restoration efforts were complete. For the first time in a long while, the controversy officially felt finished. The ranger's final report reflected that reality. Compliance had been achieved. Protective measures remained in place. Monitoring requirements were satisfied. The case could effectively be closed. That report ended up becoming one of the most widely shared documents in the entire saga. Not because of its technical findings, not because of regulatory language, but because it represented accountability. A powerful organization had attempted to control something it did not own. It assumed influence would outweigh facts. It assumed revenue would outweigh responsibility. It assumed nobody would challenge the arrangement. Instead, a simple review of property records triggered a chain of events that exposed every weakness in the plan. The irony wasn't lost on anyone. The HOA's original goal had been profit. They wanted to capitalize on the Waterfall's popularity. They wanted visitors to become a revenue stream. In pursuit of that goal, they created one of the most expensive mistakes in the association's history. The financial damage exceeded anything they earned. The reputational damage proved even worse. Years later, residents would still discuss the controversy. New homeowners heard the story shortly after moving in. The Waterfall became legendary within local real estate circles, not because of its beauty, not because of its hiking trails, but because of what happened when someone tried to monetize it. As for the Waterfall itself, very little changed. Families continued visiting. Photographers continued arriving. Hikers continued exploring the trails. People appreciated the area much as they always had. The difference was that everyone now understood something important. The land had boundaries. The law had boundaries. Authority had boundaries. Ignoring those boundaries came with consequences. One warm afternoon, nearly 2 years after the first admission booth appeared, I stood near the overlook where the entire mess had effectively begun. The water cascaded over the cliffs below. Sunlight reflected from the surface. The valley looked peaceful again. There were no signs, no fee stations, no controversy. Just the sound of rushing water echoing through the trees. Looking back, the outcome seemed almost inevitable. The HOA believed ownership and authority were interchangeable. They believed proximity created entitlement. They believed popularity created opportunity. What they failed to understand was much simpler. A waterfall does not become yours simply because you can see it from your neighborhood, and a natural treasure does not become a business merely because someone imagines a way to charge admission. The state ranger understood that. The property records proved that. And eventually, after months of investigations, hearings, penalties, lawsuits, and public scrutiny, everyone else understood it too. The waterfall remained exactly where it had always been. The people who tried to profit from it, however, would never forget the lesson it taught. And throughout the valley, the story became a reminder that some shortcuts lead directly to disaster, especially when they begin with the assumption that nobody will bother checking who actually owns the land. The end.